Hi everyone, here to make two announcements really quickly. Obviously, Trump administration seeks to implement a registration requirement. On January 20th, 2025, President Trump issued the Protecting the American People Against Invasion executive order, which has directed the Department of Homeland Security to ensure that aliens comply with their duty to register with the government under Section 262 of the Immigration and Nationality Act. Now, most recently, on February 25th, the Secretary Kristi Noem announced the Department of Homeland Security will fully enforce the Immigration and Nationality Act, which created multiple tools to track illegal aliens. This is their statement. And compel them to leave the country voluntarily. These tools include criminal penalties for certain aliens who, one, willfully fail to depart the United States, two, fail to register with the federal government and get fingerprinted, and three, fail to apprise the federal government of changes to their address. So this is their statement. This is what they're saying. An alien's failure to depart the U.S. is a crime that could result in significant financial penalty. An alien's failure to register is a crime that could result in a fine, imprisonment, or both. For decades, this law has been ignored. Not anymore. That's what they're saying. So this is basically compelling mass self-deportation is their argument. It is a safer path for aliens and law enforcement and saves U.S. taxpayer dollars, in addition to conserving valuable customs and border protection and immigration and customs enforcement resources needed to keep Americans safe. So that's the argument. But, on the flip side, also, this is, the last time that the U.S. required people to register was basically after 9/11, and the result was a gross and ineffective waste of taxpayer dollars is the reality. And so it didn't make anyone safer, arguably, and it caused unnecessary confusion and harm to thousands of American families and businesses. So this is going to result in criminalizing people who are otherwise law-abiding members of the community all across the United States, and even children under 14 years old are going to be required to register, but the U.S. government doesn't even recognize the people under 14 years old as adults. So it's obviously hypocritical what they're saying, and I don't know how correct it's going to be, and this has obviously become such a political debate, but this is obviously a trap that seeks to label immigrants as criminals, which is what the Trump administration has been doing since prior to the election and moving into the election. They're delivering on that promise, and they're not changing their rhetoric. And this is going to allow them to justify mass deportation. And we already know that a lot of people are getting arrested for situations, or even people who necessarily have asylum applications pending. There's no decisions been made. They're actually technically in status, and they're being arrested with no crimes, and they're being detained in detention centers as we speak. So this is what's going on. Who has already registered? Well, anyone who has been issued one of the documents is designated as evidence of registration under 8 CFR 264.1b has registered. So basically, there's some other INA codes that I'm not going to cite, but basically, anybody who have already registered include the following: lawful permanent residents, aliens paroled into the United States under 212d5, even if period of parole has expired, aliens admitted to the United States as non-immigrants who were issued Form I-94, even if the period of admission has expired, all aliens present in the United States who were issued immigrant or non-immigrant visas prior to arrival, so prior to the time that they entered the United States, aliens whom DHS has placed into removal proceedings are already registered, aliens issued an employment authorization document are registered, aliens who have applied for lawful permanent residence using forms 485, 687, 691, 698, I-700. Even if the applications were denied, they have been registered. So, and then lastly, aliens issued border crossing cards. So a lot of people many years ago were being issued border crossing cards to basically cross over from the Mexico-U.S. border. So that's who's registered. Who is not registered is going to be aliens who are present in the United States without inspection, admission, or inspection and parole. Canadian visitors who entered the United States at land ports of entry and were not issued evidence of registration. So even Canadians are going to have to register if you basically were not fingerprinted and did not enter at the port of entry. Aliens also who submitted one or more benefit requests to USCIS not listed in 8 CFR 264.1a, including applications for deferred action for childhood arrivals or temporary protected status, who were not issued evidence of registration, will need to register. How will they need to register? DHS will soon announce a form and process for aliens to complete the registration requirement beginning February 25th. Aliens required to register should create a USCIS online account in preparation for the registration process, and there's other resources online, so you can Google this, go to the USCIS website. And then one other quick announcement is basically as of yesterday, March 3rd, USCIS website states currently effective versions of Form I-485 application to register permanent residence or adjust status, so that's for your green card application, or Form I-918, petition for U non-immigrant status, which is for the U visa, which is for victims of crimes, specific crimes, who are basically cooperated with police in their interrogation and prosecution of that individual or prosecution of that individual. So Form also I-912, application for advance permission to enter as non-immigrant. That's for anybody who's trying to have permission to re-enter the country after departing from the country and are in non-immigrant status. The form, which means basically they're on a temporary visa or some other non-permanent type of visa. Form I-134, declaration of financial support also, and Form G325A, biographic information for deferred action, are the January 20th, 2025 editions of each form. So for all these forms, the form needs to be the January 20th, 2025 edition. And what does that mean? At the bottom of the page of each form, you should see that date, January 20th, 2025. Make sure the form edition date and page numbers are visible at the bottom of all pages, and all pages are the same edition. So form that has the January 20th, 2025. For any form, you go to the USCIS website, you can see which edition date is for that form. So if it's any other forms too, just quick tip, that's what you want to do. If any page is missing or form different, it's a form of a different edition version, then USCIS may reject it, and they often do. So this is a very important thing. I just submitted 2 complete adjustment of status applications, marriage-based, with the I-485s yesterday myself, and it appears that there's going to be no grace period, so I hope they accept it and they process it, but I'm anticipating that they might reject it, even though they just made this announcement off the hand yesterday, and they just stated on their website. So keep an eye out if you filled out the 485 or any of these other forms. I know it's annoying, but you want to go and redo it and make sure you have the version that is the January 20th, 2025. Okay, if you need anything, reach out to me, rodarmandalaw.com. Take care, guys, and stay tuned for more updates.